AI is compressing the time required to research. And when time compresses, gatekeeping shifts. Let me tell you what that means and why it changes everything for every employee who has ever walked into a room that was not designed for them. Hi, I'm Imani, your AI career coach. Welcome to Workplace Intelligence Trademark, where when time compresses, gatekeeping shifts. This is where employees become informed, prepared, and powerful, equipped with the tools, knowledge, and education they were never taught. Not in school, not at work, not before we needed it most. This is not legal advice. This is something more powerful than that. This is education, and it's personal. This is a special episode of Workplace Intelligence, Trademark. And today, for the first time, we are going to talk about the person behind this series. Not because she needs recognition, but because you deserve to know who is in your corner. And because the entities on the other side of your case, the employers, the insurance companies, and the opposing attorneys, should understand who they are dealing with. Charnice Lanier is a business owner, AI transformation operator, and business intelligence strategist, a trader, and a finance strategist. She holds multiple AI certifications. She has built several AI businesses. She has 36 years of professional business experience, online and offline. She understands risk management, not as a concept, but as a practice. In 2014, before AI existed as a research tool, she represented herself pro se in a complex civil legal proceeding without an attorney. Without AI. Without any of the tools available today. What she had was something else. A commitment to research. And a refusal to be intimidated by a system that counted on her not knowing the rules. She won. Today, she is simultaneously navigating a wrongful death case pro se for her father, while advocating for an injured employee in a workers' compensation battle, while assisting another employee fighting wrongful termination and wage theft, while building workplace intelligence trademark, and while running multiple AI businesses. This is not theoretical for Charnice. This is not academic. This is not a business opportunity. This is personal. She has experienced the system from every side. As an employee, as a business owner, as an advocate, as a daughter, and as a mother with a son preparing to enter the North Carolina workforce as a civil engineer in spring 2026. And every single time, she chose to learn the rules instead of surrendering to them. But the victory in 2014 came at a cost. 1 month of research, hours searching government websites for statutes, days reading case law line by line, weeks of building the confidence to walk into a room where legal language sounds like a second language, where bailiffs, attorneys, and judges speak a language most ordinary people were never taught, and an emotional toll that only someone who has navigated the legal system alone truly understands. But the gate was still there. She simply climbed over it, one exhausting inch at a time. Now let me tell you what happened in 2025. Charnice began assisting an injured employee navigating a workers' compensation case. An employee who had been assaulted at work, whose claim was denied, whose assault was reduced to horseplay, who was suspended during an investigation she was excluded from, and who walked into mediation with a settlement demand of over $100,000, only to watch it get reduced to $15,000 in minutes. The employee was handed a global release and a resignation, and told this was common in North Carolina, that it could not be negotiated. But something happened next that changed everything. Within days, not months, the numbers told a different story. The real case value, 239,676. The statutes were identified. The misconduct was documented. The demand letter was sent to 8 parties simultaneously, 8 gatekeepers who controlled the money or supported someone who did. The manufactured deadline was exposed, and the attorney withdrew. 3 minutes after, his partner saw the receipts. Same Charnice, same intelligence, same determination, same refusal to be intimidated. But this time, the research took 1 evening instead of 1 month. Not emotionally drained, not overwhelmed, not exhausted, searching for information that should have always been accessible. Calm, prepared, in control. So what changed between 2014 and 2026? Not the law, not the system, not employer tactics, not attorney misconduct, not gatekeeping. The time it takes to understand your rights. AI compressed the time. And when time compresses, gatekeeping shifts. Because when information stops being scarce, employees become more powerful. Now, let me talk about something workplace education rarely addresses: the difference between having an attorney and being represented. In this case, the employee had an attorney, a board-certified workers' compensation specialist, whose firm published a handbook warning employees not to settle in a hurry, whose firm promised competent representation in a client bill of rights. And yet the employee still had to research her own case value, calculate her own compensation rate, identify her own statutes, draft her own pre-mediation email, build her own negotiation ladder, and send her own demand letter, with an attorney on record taking 25% of whatever she recovered. Because here is something most employees discover too late. Having an attorney and being represented are not the same thing. Most employees only learn that difference after they are already sitting across the table from professionals who have prepared for that moment for years. So what does an employee actually need? Not 5 professionals, not a complicated team, not a committee of specialists. One person. One person who combines coaching, strategy, research, advocacy, and navigation. Someone who sits beside you at every step. Someone who prepares you before you enter any room. Someone who documents everything in real time. Someone who understands the difference between indicated and confirmed. Someone who catches the details others miss. Like a 2017 date appearing inside a 2026 legal email for a 2026 hearing. Someone who calculates your case value before a mediator ever opens their mouth. Someone who sends the demand letter before the fake deadline. And then an attorney, a competent one who actually represents your interests. That is the entire team. One advocate, one attorney, and one AI research partner. Perplexity, ChatGPT, or Claude. Here is why this matters for employees. Most employees do not run their household like a business. Most employees are never taught risk management. And the system knows this. The complexity of the legal process is not accidental. The overwhelming paperwork is not accidental. The pressure tactics, the calls, the deadlines, the manufactured urgency are not accidental. The overwhelm is the strategy. The confusion is the control. The complexity is the gatekeeping. When injured or traumatized employees cannot process events fast enough to respond strategically, they sign. When they are financially desperate, they sign. When they feel alone in a room full of professionals speaking a language they were never taught, they sign. And the system moves on to the next file. But everything changes when one informed person stands beside you. The overwhelm has somewhere to go. The confusion gets translated. The complexity gets navigated. The pressure gets documented. And the room that was never designed to include you gets entered anyway, on your terms, with your numbers, with your statutes. You do not have to be the smartest person in the room. You do not need 36 years of business experience. You do not need AI certifications. You do not need a law degree. You need one person, the right person beside you, using the right tools, asking the right questions. Because AI is the most powerful research tool ordinary people have ever had access to. It does not replace attorneys. It does not replace advocates, but it compresses the time. And when time compresses, gatekeeping ends. When the gate opens, you walk through, not because the system changed, not because employers became kinder, not because attorneys suddenly became more ethical, but because you showed up prepared in a room they did not expect you to enter. That is workplace intelligence trademark. And that is why, one informed worker at a time, gatekeeping shifts. If you are navigating a workplace situation right now and need guidance, visit Playlist 1, title Workplace Intelligence Trademark. Know your rights to learn how Shornies guide employees directly. And if you want to see exactly how this research changed the outcome of a real case in real time, subscribe and put your notifications on for Wednesday. Playlist 2, title Workplace Intelligence Trademark, Case File 1, The Assault They Called Horseplay, and watch Episode 1, Why I Didn't Google It. And download the free AI prompt guide for legal research in the description below. These are the same prompts used to research a real case and calculate a $239,676 case value in under 1 hour. Use them. You do not have to figure this out alone. You were never supposed to. So tell me in the comments, have you ever felt alone in a room that was not designed for you? Comment yes or no. Your answer helps shape future conversations. The rules exist. The system exists. And once you learn the rules to the games being played in the workplace, you stop playing defense. You start winning. I'll see you Monday.